Hi, everybody. First of all, happy Nurses Week. Hope you all are having a good one, and I hope you also had a good Mother's Day as well. This week, I wanted to change it up a little bit. We are waiting for the governor's report in terms of opening up the general public. As everybody knows, we have the stay-at-home order that goes through till May 18th. We're waiting to find out if that's going to be extended or if it's going to be extended with some limitations. There's a press conference this afternoon at 1 o'clock that we anticipate there'll be some answers on that. There is an advisory group that is discussing this. We did already give the governor some feedback on that, not the least of which is that the advisory group doesn't really contain folks from the front line in healthcare and other essential workforce groups, and that needs to happen. We think probably there should be a separate advisory group altogether with frontline workers on all the essential services to give the best direction about how to best open up safely for the public. That being said, what I do think would be good to do is we have over the last 6 weeks, not surprisingly, heard from a lot of nurses, a lot of members, basically raising the issue that they have attempted to actually file a workman's compensation claim and run into a great degree of difficulty. Most of the hospitals are self-insured on workman's compensation, so they run their compensation claims out of their own insurance vendors, for lack of a better word. And they may be run out of different departments, HR and employee health, occupational. They may be all very different within each system, but really, to a fault, we've heard from a number of nurses in all the systems saying that they're getting the answer back, well, we don't think necessarily that you got this at work, you might have gotten this at the grocery store, which is obviously enormously disconcerting for any of you to hear, given the circumstances that you've been in. You're pretty much in a petri dish. So we thought it would be a good idea to invite an expert in the field in and to be able to do a Q&A that might help answer some questions for you and give you a little leg up, if you will, on how to file the claim, for workman's compensation. Charlie Donahue is an attorney who works in workman's compensation. He's well known to the M&A and has worked with a number of the nurses who are members here with very good results. And we're happy that he's going to be able to be with us, along with Judy Perry, who's the director of the Nursing Division in Education, to do a Q&A on this issue. So I hope this helps answer some questions for you all. And if there's any other issues that are arising for you in the field that we can bring some expertise in, we'd be happy to do so. Thank you.
I think the most important thing is to report to whoever the appropriate party is. It could be your nurse manager, it could be OC Health, it could be a variety of different parties that is designated by the facility. So that's supposed to be posted somewhere in the facility. One would assume it's probably employee relations or somewhere. But someone needs to be able to provide you with that information. You don't have a lost time claim until you've been out for 5 days, and you don't get paid for the first 5 days until you've been out for 21 days. But in any event, getting back to the threshold, it's reported to someone. And you may find, I think in this circumstance that we're living in right now, that it's best to report it to as many people as you can. So report it to your nurse case manager, report it to OC Health, report it to employee relations, whoever, because I think that way you're not going to face down the road, oh, well, you didn't tell us. We didn't find out about this until 10 days later. I mean, if it means doing it with an email or doing it with a text message, something that you can later use to memorialize that, or prove that you, in fact, did give them notice. So notice is critical. Well, if you have what's known as a lost time claim, a lost time claim is going to necessitate not only the filling out of the claim form, but it is going to require that you have a medical report which essentially states that you have COVID-19, that you've been diagnosed with it, and that the reason that you're out of work is because of the COVID-19. Now, that sounds like a lot, but it actually could be an ER visit. It actually could be a visit with your PCP, and that individual could write something in the note that says that. But you need that to get over the hump. You need that to get past the first step of the litigation process. Well, I think it's important because for a couple of reasons. First of all, the claim form includes witnesses. And so you want to know who you spoke to. You want to know whether you told a coworker. You want to know whether you mentioned it to Dr. Smith or whoever you discussed it with. And that's important because I think down the road, you're going to face a claim where they send in a defense attorney. The defense attorney is going to try and put holes in everything you say. And one of the ways to do that is to find inconsistencies. So if you have witnesses, if you've told people what's going on, and then you again have written that down in a journal, contemporaneous to when you've had these discussions, I think that'll prove very, very helpful as the case moves forward if it becomes necessary. First of all, should never include a room number. I think you should, never obviously include the name of someone. I think generalities in terms of, I was treating patients on floor X and I saw, 3 patients who were COVID positive, or my journeys take me through the emergency room. There are people sitting there that may in fact have been exposed and maybe there for testing purposes. So I think you can do it without naming names. Clearly, you don't want to do that. And even sometimes the thought of, specifying a room could be problematic, although not quite as much. But you need to obviously respect the patient's rights, and my guess is HIPAA is something that will be utilized again by the defense if you were to become too vocal even in writing form about I was treating Mary Smith and Mary Smith has COVID. You don't want to do that. I think again it gets back to reporting it to a number of different sources. But once you have been out for 5 days, again it technically becomes a lost time claim. In the atmosphere we're in, many people are, quarantined for 14 days and then they're ready to come back to work, and they may or may not want to pursue a claim to establish that in fact it was COVID-19. That's a horse of a different color. It's a far more involved discussion. But if you're not getting a response, quite honestly, I would send somebody a certified letter. I would make sure that they received it. And or consult with an attorney because he or she can be more aggressive, let's say, in notifying the employer. And you're going to have a lot of those. I think you're going to have a lot of those circumstances where they're going to say, oh, you got it at Stop and Shop or Shaw's or Market Basket. And the case law, as it stands today in Massachusetts with respect to infectious disease, is pretty straightforward. And it comes down to a test of more likely than not. And so if you've been in your personal life consistent with the restrictions that we're all hopefully trying to live with, but you go into the hospital and where you work, whatever, 12, 14, 40 hours a week, then I think a significant number of the judges at the Industrial Accident Board will look at that and say, okay, that meets the test. You're in a special circumstance because you're a nurse, you work in a hospital, and COVID-19 is, prevalent in this atmosphere. So I think they have the law on their side right now, but I can also anticipate that these are going to be aggressively defended. I think that if you're able to, at least personally, have the ability to keep records, you or someone close to you who hopefully will be able to do the same thing for you. It makes it easier again down the road if you have to pursue litigation. Most lawyers, if it becomes the fact that you need a lawyer, they will get authorizations for medicals and things like that. But especially in the beginning, if you have someone who has been out for 14 days, and then most don't go anywhere until someone's been out for 21 days. And if you file a claim, then you're going to want to have something right away to be able to use. And again, you need a medical record of some sort, doctor's report, that states that you have been exposed, you've been tested, you're positive for COVID-19, and that your reason for hospitalization or your reason for being quarantined is just that. And that would be attached to the claim form. You have to have a medical to go with the claim form. Absolutely. And you know, I don't want to appear to be, you know, negative toward any entity, but nobody's going to help you except yourself. And I mean, if you do retain someone to represent your interests, because they just don't want to know. They would far prefer to say, oh no, we think you got it, you know, in the supermarket. We don't think you got it here, because given the numbers, it's, you know, to them it'll become a battle. Again, this is one of those things that they will aggressively defend. So it is important. Well, if they file a claim with the necessary medical, the litigation process is three-pronged. The first appearance is called a conciliation. And if you are pro se, acting on your own, you would go into one of the regional offices throughout the state. Although at the moment they're doing them by video conference, and you would present your medical evidence, which, quite honestly, the conciliator already has in front of him or her, and it must be necessary to get it moved on to a judge. Only a judge can establish liability. So that's the first instance, and where you would need the medical evidence. The second stage is called the conciliation. I'm sorry, the conference, and the conference is before a judge. And again, those, as of the moment, have been again utilizing video. And it's interesting. It's new to everybody, and so there are a lot of little things to be worked out. And quite honestly, I doubt very many. I don't think any have gone forward because, you know, the DIA, for all intents, Department of Industrial Accidents, hasn't been open. So there's going to be a rush in a matter of whatever, 2 weeks, whether it's the 18th or whether it's a couple of weeks after that. There'll be a rush. But so that's the conference stage. The judge issues an order. He or she either finds that it's that liability attaches or doesn't, then you can appeal that within 14 days if you don't like the judge's decision. Ultimately, it would go to a hearing, and that's a hearing under oath. And there's a stenographer. It's very similar to it is a courtroom for all intents. It is a courtroom. And most of the rules of evidence are followed. You would testify. Any witnesses you had would perhaps come in and testify. And prior to that, you would have been sent out for an impartial examination under the rules. And the impartial doctor would take the medicals presented by the hospital and your medicals, and then he or she would examine you and issue a finding. Their finding is very important, but it's not the be-all and end-all. So again, that gets into the weeds. But that's the third stage. And then, if one of the parties didn't like the decision of the judge, they could appeal it to the reviewing board, and that's a further process where the lawyers are the ones who prepare legal analysis, submit them to the reviewing board. They may or may not want to hear oral arguments, and that's a time-consuming, probably 3-4 months. It's gotten a lot better. It used to be a year. So litigation is not something that most of my clients in the nursing world are crazy about, because you're people of action, and there's nothing that moves slower than litigation. That will probably be within 21 days of you filing it. Again, assuming everything is correct, about 21 days. Could be less. And the second phase could be, under the best of circumstances, depending upon the region. Boston is the busiest region. You could end in Worcester. You might see a turnover of 2 months, 3 months, and so then the next phase, though, is the hearing, and that's when it's going to slow down, because the state will rely on doctors on their list and they'll have to have a specialty obviously in contagious disease, and I doubt there are very many of them. So that could slow the process down you might not see a hearing for, I don't know, 4, 6 months. There's a 2-year statute of limitations. It's not always adhered to. It has something to do with when you actually find out that you were exposed. So there are, say someone wasn't diagnosed for, 6 months, 7 months, 8 months, close to the 2-year period. As long as that's when they first became aware of it, then the Industrial Accident Board is far more generous in terms of statute of limitations than the courts are. Yes, that's one of the avenues that certainly can be pursued, or calling the Department of Industrial Accidents and asking for someone in the conciliation unit if things appear to be slowing down. So they're very attentive. They're very helpful.